first case to come before the Board of State versus Hamilton. The court is ready to proceed. We have, you have each 15 minutes to present your arguments, and the appellant may reserve up to 5. Just please let me know. Thank you.
Please, the court, my name is Michael Stepanek. I represent defendant appellant Lorain Hamilton. If possible, I'd like to reserve 5 minutes of time for
That would be fine, thank you.
Mr. Hamilton was arrested, charged with trafficking, possession of drugs, went through a jury trial, was found guilty. The jury was asked to determine the weight of the controlled substance that he was, if he was found guilty of a controlled substance, in possession and trafficking of a controlled substance. The second question was, what was the weight of that controlled substance? Because, as the court is aware, depending on the weight, that is tied to the penalty. And the question then was, well, how do we tell the jury, how do we instruct the jury what the weight is? Do we say it's just of the controlled substance he's charged with, of cocaine, or do we say it's the entire mixture? And the court, against counsel's objection, over counsel's objection, said that the jury is to weigh the entire mixture. Now, there's a couple of problems with that. First being, the court is aware of a case, State versus Gonzalez, which states that in order to have someone guilty of anything above a felony of the 5th degree, the state is required to prove the amount of cocaine, not necessarily the purity of cocaine. I know in a lot of the briefs purity is mentioned, but it's just the amount of cocaine. And that case, I know State versus Gonzalez out of the 6th District is currently on appeal with the Ohio Supreme Court. They did oral arguments this past February. We're waiting for a result in that case. But over and above what we perceive to be an error with permitting the court or the jury to weigh the entire mixture, the other thing that I think is notable in this case is the lab tech was asked when she was on the stand, well, is there any evidence of a mixture in this case? And she said no. So I think that this case is a little more interesting than the Gonzalez issue, because Gonzalez says you'd only weigh the actual cocaine in the mixture. Other cases...
How do you chemically disassociate the actual cocaine purity from the balance of the stuff in the mixture? How do you do that, and who's paying for that?
The state of Ohio.
Okay, so you're saying that anytime somebody's arrested for cocaine or crack cocaine and stuff, we're supposed to separate out specifically what the cocaine part, pure cocaine, from the balance of the entire mixture of compound? That's
what the Ohio legislature has directed. Because, presumably because they say when you look at the penalty, you're looking at the amount of cocaine.
In the mixture?
Correct.
Or compound?
Correct.
Or the other thing?
Correct. Correct. And that's what they say. So they don't say, and every other, and I think it's spelled out in the brief, and also in Gonzalez case, every other basically controlled substance says you weigh the entire thing. For cocaine, it says you can weigh the entire thing, but then how much of it is cocaine? And I think that if you were to take out the words of cocaine, then the state has it the way that they want it. But I don't think that that's the case. I know that the state has argued in this and other cases that, the requirement to prove cocaine or the amount of cocaine would lead to an absurd result. I don't think there's anything absurd about it. I don't think the state has asserted that there's anything absurd about it. What they say is, well, we don't have the capability to do it because nobody's ever told them that they have to. The Ohio legislature has. They haven't done it. There are other states that do it. So I don't think that anybody in those states can say, well, that's absurd because it's difficult. There are labs, and in this case and in other cases, where Elizabeth Doyle, the lady from across the street who runs the drug lab, says, yes, it's entirely possible to do, I don't call it purity testing, but to determine the amount of cocaine that is in this mixture. We don't do it because we haven't been told we have to. So I don't think there's anything ridiculous about asking them to do it. I don't think that that necessarily leads to an absurd result. So, and again, I think that over and above the fact that, or whether you have to weigh the cocaine itself, the lab tech in this case says, I don't have any evidence of a mixture. So I think that one of the biggest issues in this case was the Court of Appeals, the trial court had directed the jury to figure out how much cocaine was in this mixture, and we know that the jury instruction has to mirror the facts of the case, but the lab tech was asked a specific question, did you see a mixture in this case? And she said no. So they're asked to assume a fact in the jury instructions that wasn't even in evidence, actually the exact opposite. So you could have a situation, if you want to talk about an entire mixture, where the state could have offered testimony from their lab technician to say, I found a mixture of cocaine and other things. What she said is she identified more than one chemical or more than one item in her lab test. But mixture has a definition, compound has a definition, the state didn't elicit any of that testimony. So what the lab tech will say is she takes a tiny little spatula, gets a tiny bit of a sample, and tests it. She has no idea, and has testified as such, how much of the rest of the sample contains any cocaine or the other sample. She was asked, is it possible that the tiny bit you took had cocaine and the rest of it was not cocaine? She said, yeah, that's possible.
Was it likely?
I don't know. I don't know the proclivities of each individual drug trafficker, and I think that that would be, the burden would be on the state to establish that. We don't have situations in these two cases where individuals were charged with, or I'm sorry, they don't have a controlled buy type situation where someone's actively selling it. These are things that were, in this particular case, this was a big bag of 90-some grams of cocaine. So yes, I think it is likely because drug traffickers, and there's a lot of testimony from the officers in this case, drug traffickers will typically use what the Lorain County Crime Lab calls adulterants, other people call cut, and they make it look like cocaine. They mix it in there. So is it entirely likely that a drug trafficker could have a very large amount of cut, a very little amount of cocaine? Yeah, I think it's very likely. I think that's probably, the more cut that a drug trafficker has, the more fake cocaine, for lack of a better phrasing, they can make. So yeah, I do believe it's likely. I do believe it's very likely.
And what's the purpose of having fake cocaine?
Selling it.
I know.
Sell
And for
it.
what?
To make money.
No, but to also lead the person minded to believe that it is cocaine, that they're trafficking in cocaine regardless, right?
Could be. If this was an offer to sell case, I'd say maybe that has more relevance, but this was a big sack of cocaine that was in a bedroom somewhere. So this isn't being represented as cocaine. There's no offer to sell cocaine in this case.
But that's one of your arguments, that it could be something other than cocaine.
Well, it's not one of my arguments, it's something that the lab tech said. So that's something that the...
Because she didn't test the full...
No, she didn't. She didn't. She actually said that this could be, for all she knows, this is the substance she tested, visually homogeneous. She has no idea whether it's chemically homogeneous. She only takes a tiny little piece. She won't even test other parts of the sample unless they look different.
If the legislature thought that the whole entire sample should be tested, then it should be separated out so we know precisely how much cocaine is in the mixture compound, whatever it is. Why didn't they just say that then? Because that's not the way it's written. So my question is, if that's what they intended, that you should only be cited for specifically how minuscule amount of cocaine is in your 93-gram bag, wouldn't they have said that?
I think they did say that because they said you are to be punished for the amount of cocaine in the mixture or sample.
But the definition of cocaine in a different statute says what?
The definition of cocaine is in 2925.01X, which has a derivative of the coca leaf. Try to find it exactly. I printed it out separately for today.
Doesn't the statute say any compound, which would imply the entire bulk?
Any compound for the definition of cocaine?
Well, my notes aren't that complete.
Oh.
I was left with the impression that the law has somehow changed and that if it tested positive for cocaine, the entire compound or any compound, meaning the entire bag and its mixture or filler.
What I think Judge Whitmore is referring to, because I was just looking at on page 11 of the state's brief, it says that cocaine is used to describe the drug involved as a compound, mixture, preparation, or substance containing cocaine, and it's 292511C4.
I don't think that the state has any statutory support for that. There's some case law support for that. I put in my brief, there are, I don't know, at least a dozen, if not more, cases that rely on prior amendments to the law that say you're supposed to weigh the entire thing. There's definitions of bulk amount that you're still seeing in some of these cases. When you look at the statute as it exists now and it existed back then, there's nothing about bulk amount anymore. That's all been removed. So all of those cases, there are still cases now that cite a case from 1997 where the Court of Appeals in 1997, based on totally different statutes, say you're to weigh the entire thing. Well, if the statute hadn't changed, that would still be good law. But the statute had changed. The statute's changed dramatically.
Counsel, you're into your rebuttal time if you'd like to say something.
I'll say.
Thank you.
May it please the court, Elizabeth Lindberg on behalf of Appellee, the state of Ohio. Larry Hamilton was indicted by a grand jury on November 20th, 2014. He was charged with trafficking in drugs, a felony of the first degree, possession of drugs, felony of the first degree with specifications on both of those, possessing criminal tools, drug paraphernalia offenses, and then possession of drugs, a minor misdemeanor. Then there was a supplemental indictment making that count 6, trafficking in drugs, felony of the first degree, and major drug offender specification and a forfeiture specification that ultimately replaced count 1 of trafficking in drugs. The case proceeded to a jury trial. The jury found Mr. Hamilton guilty of all counts, and then he was sentenced to an aggregate sentence of 11 years. As this court is aware, 2 of the assignments of error presented here, specifically 1 and 2, are pending a decision by the Ohio Supreme Court in State v. Gonzalez, 2015-0384. Additionally, relative to the trafficking in drugs, there is a case, State v. Sanchez, also from the 6th District relative to trafficking, and the Ohio Supreme Court also has that case on appeal, and the appeal has been accepted and the cause has been held for a decision in State v. Gonzalez. Mr. Hamilton, in his first assignment of error, raises the issue of insufficient evidence for failing to identify the disputed substance as cocaine. As this court mentioned in 292501X, the definition of cocaine says it means any of the following: a cocaine salt, isomer, or derivative. Then in the second portion it says coca leaves are a salt compound, derivative, or preparation of coca leaves. It goes on a little bit, and then in the third section it says a salt compound, derivative, or preparation of a substance identified in division X1 or 2. The definition of cocaine itself includes the term compound. Again, then, in 292511C4 and 292503C4, it states if the drug involved in the violation is cocaine or a compound, mixture, preparation, or substance containing cocaine, whoever violates Division A of the second is guilty of possession of cocaine. So it includes cocaine or a compound, mixture, preparation, or substance containing it to make someone guilty of possession of cocaine. In this case, the officers found at 1485 F Street in Lorain that there were bags of cocaine. Elizabeth Doyle from Lorain County Crime Lab testified, and she found that in one bag there was 97.28 grams, and in 3 other bags together there were 83.05 grams. Both of these bags, or all of these bags I should say, contained cocaine and levamisole and adulterant.
Well, now the weight, how did she separate out the cocaine to assign a specific weight to it?
that was the weight of the entire bag. She was not able to parse out cocaine from the remaining mixture. Presently, it appears that appellant is arguing that she never testified as to it being a mixture or a compound. Clearly, statutorily, if the drug involved is a compound, mixture, preparation, or substance containing cocaine, then that is sufficient under the statutory law. In this case, whether or not she used the phrase compound, mixture, preparation, I don't think those are necessarily magical words that need to be said. If it's cocaine and levamisole, which is an adulterant, that in and of itself isn't just one thing, it's a mixture of more than one item. So therefore, it's the controlled substance mixed with something else. As the state cited in its brief, purity has never been required previously. Prior to the 6th District cases of Gonzalez and Sanchez, courts have not required determining the precise amount of cocaine contained within the discovered drug. This court is amongst the other courts in never requiring doing a purity testing of the drug that's been found. That's in State v. Troutman, State v. Seymour, State v. Shinholster. Again, as mentioned, Hamilton presently relies in making his argument that purity is required on State v. Gonzalez and State v. Sanchez from the 6th District Court of Appeals. Notably, those are not binding precedent on this court, and both are pending decisions in the Ohio Supreme Court. Importantly, drugs containing cocaine, as cited previously, are traditionally a compound, mixture, preparation, or substance containing cocaine. In other cases, crack cocaine always is a mixture of cocaine along with other items. It's particularly challenging for drugs containing powder cocaine and all but impossible for drugs containing crack cocaine to determine the amount of pure cocaine contained within that drug. As far as statutory construction, a court cannot pick out one sentence and dissociate it from the context, but must look to the four corners of the enactment to determine the intent of the enacting body. That was the Ohio Supreme Court in State v. Wilson. The Ohio Supreme Court then in State ex rel. Saltzman v. Burton, statutes must be construed, if possible, to operate sensibly and not to accomplish foolish results. Here, Hamilton wants the word cocaine to supplant the essential element of the offense, in which the word cocaine is used to describe the drug involved, which can also be a compound, mixture, preparation, or substance containing cocaine. In his second assignment of error, Hamilton argues that the trial court erred when it instructed the jury that the amount of the controlled substance includes the weight of any mixture that includes some detectable amount of a controlled substance. This court will review this assignment of error under an abuse of discretion standard. And a reviewing court must examine the jury instructions in their entirety to determine if they fairly and correctly state the law applicable to the evidence presented at trial. That's what this court said in State v. Franklin, 2006, Ohio, 4569. Here, the court said at transcript pages 454 and 456, if your verdict is guilty on count 1 or count 2, you will separately decide beyond a reasonable doubt if the amount of cocaine involved at the time of the beyond a reasonable doubt the amount of cocaine involved at the time of the offense. If your verdict is not guilty on count 1 or count 2, you will not decide this issue. The amount of a controlled substance includes the weight of any mixture that includes some detectable amount of the relevant controlled substance. Hamilton again relies on State v. Gonzalez. That is not the present state of the law. The trial court correctly utilized both statutory law and case law, being State v. Chandler, 2006, Ohio, 2285, in instructing the jury as to what the juror should consider when determining the weight of the controlled substance in this case. In his third assignment of error, Hamilton claims that the trial court erred because the guilty verdicts are against the manifest weight of the evidence. Specifically, Hamilton claims that no evidence showed that Hamilton had control or possession of the premises at 1485 F Street. In reviewing a manifest weight of the evidence claim, an appellate court must review the entire record and weigh the evidence and all reasonable inferences, consider the credibility of witnesses, and determine whether in resolving conflicts in the evidence the trier fact clearly lost its way and created such a manifest miscarriage of justice that the conviction must be reversed and a new trial ordered. Again, this should only be used in extraordinary circumstances when the evidence presented weighs heavily in favor of the defendant. Importantly, possession of the premises where contraband is found is not necessary to show possession of that contraband. In this case, possession under 292501 is having control over a thing or substance, but may not be inferred solely from mere access to the thing or substance through ownership or occupation of the premises upon which the thing or substance is found. Factually, in this case, the state presented ample evidence that proved to the jury that Hamilton was in possession of and trafficking in the controlled substances in the house at 1485 F Street, Lorain, Ohio. There were drug complaints that Larry Hamilton was at that residence trafficking in drugs. The detective received or was able to take pictures of Hamilton conducting surveillance when they began conducting surveillance of the residence. They viewed Hamilton leaving and returning to the residence. They believed that his girlfriend was living there. From trash pulls, the detectives found mail addressed to Larry Hamilton, sometimes to other addresses. At least once, a piece of mail registered to Larry Hamilton at 1485 F Street. In those same trash pulls, they recovered bags or baggies with residue that had presumptive positive field tests for controlled substances. When the search warrant was executed, Larry Hamilton was present at 1485 F Street and was upstairs. There were no other individuals in the house. The officers found a state of Ohio ID card for Larry Hamilton. It listed a different address than the F Street address, but it had been expired for over a year at that time. On cross-examination, Detective Heathcote said it is not uncommon for drug dealers to use an address of their girlfriends and never change their old address. That's at transcript 218. Also on redirect, he elaborated why he did not run a current check of Hamilton's address, stating that it is not uncommon for drug traffickers or someone committing a crime to not change their address or to give a false address. The police also found a rent payment sheet for Hamilton's girlfriend in the home. They found him, as I said, upstairs in the bedroom, and in the room Hamilton was exiting, police found a large sum of money in the dresser, along with Hamilton's ID, a bag filled with a large amount of cocaine on a bookshelf, a large bag of crack cocaine, and 3 bags of powder cocaine. There were also men's clothing and men's cologne found in that room. And Detective Cologne stated when asked why they didn't fingerprint the bags of controlled substances, he stated the large sum of cocaine that we located in the master bedroom where Hamilton was sleeping, based on investigation ran by Detective Heathcote, it was clear-cut the drugs belonged to Mr. Hamilton. Also in the home, they found other things consistent with drug trafficking, including plates with residue, razors, latex gloves, sandwich baggies, a digital scale with residue, a hammer with residue, etc. All of that information, all of that testimony elicited at trial is sufficient under manifest weight of the evidence standard to find that Mr. Hamilton was in fact in possession of and trafficking in cocaine in that residence. In assignment of error 4, Mr. Hamilton claims that the trial court erred in denying his motion to suppress when the police department relied on false and unreliable information to get the search warrant for 1485 F Street. Importantly, it should be noted that defense counsel did not provide an offer of proof, nor did he point to specific portions of the search warrant affidavit that were false. And in failing to provide those, Hamilton was not entitled to a hearing in the first place, and the trial court properly could have denied his motion to suppress on that basis alone. Assuming arguendo, however, that because there was this hearing, if that information had been removed, specifically about the informant who told them that Mr. Hamilton was drug trafficking out of that residence, and also that there were trash pulls that field tested positive but tested negative in the lab, assuming that was removed, there was still sufficient probable cause to justify the issuance of a search warrant, as these were not the only bases for finding probable cause in this case. The trial court, in ruling on the motion to suppress, provided that they went to the second issue in Franks v. Delaware and stated that they would determine, assuming that there was something wrong with the search warrant, whether, or they had relied on false information, that whether the balance of the affidavit would still support finding of probable cause. They found, the court stated that even if the statements averred by Detective Heathcote relative to the field tests of objects that later tested negative for contraband were stricken, a review of the affidavit leads this court to find that probable cause still existed for the issuance of a search warrant based upon the totality of the circumstances and facts supporting a likelihood that the property at 1485 F Street contained contraband. Specifically, the other trash pulls and the information provided by the confidential informant provide probable cause in this matter. He then addressed the fact that Hamilton took exception with the fact that the informant was not determined to be a reliable source of information, and the trial court said such an averment is not necessary, whereas in this case, other information corroborates the information provided by the confidential informant. The numerous trash pulls that produced both positive field tests and lab tests did that. As such, lack of averment of the reliability of the confidential informant is not fatal. The trial court cited to State v. Norris, 2006, Ohio, 4022, in finding that. Also, all of the other factors allowing them to appropriately find probable cause in this case. They conducted surveillance at the house at 1485 F Street, watched him arriving and leaving the residence. They viewed vehicles of known drug dealers in the driveway. They were aware of his drug trafficking history. In the trash pulls, they found several items that tested positive through field testing, and then also tested positive for cocaine when sent to the lab. A strainer from one of the trash pulls also tested positive for a controlled substance. They found empty bottles of VitaBlend that could be used as a cutting agent. So in light of all the information provided by police, even assuming the portions debated by Hamilton are removed, probable cause still existed to search the house at 1485 F Street in Lorain. For the foregoing reasons, the state, are there any questions?
And you are out of time, so.
For the foregoing reasons, the state asks this court to uphold the decision of the jury and trial court and affirm Hamilton's convictions and sentence.
Thank you.
Thank you.
Regarding the fourth assignment of error, I think it was relevant that the trial court said, well, the officer maybe should have disclosed that some of these trash pulls came back at negative as part of their fuller investigative report, but the fact that they didn't, I still find probable cause. The thing that I took most issue with was an officer signed an affidavit indicating that things tested positive for drugs, knowing that there was a test sent for confirmation. The officer had in his possession knowledge that the crime lab said there's no controlled drugs, yet he still signed an affidavit and sent it off to the judge with false information. And I think that's outrageous, and I think that the trial court should have taken more issue with that. But beyond that, going back to the cocaine argument, the state had indicated to the court that, well, the lab technician said that she found 2 substances, so clearly that was a mixture. Well, the lab tech testified in this case. The question was, did you find a mixture in this case? She said no. That was their witness. So now the state says, well, they found a mixture. They didn't. They actually testified there was no mixture. They had no idea how much of anything other than that little tiny little piece that they tested was cocaine. I think the confusion lies in the difference between the offense conduct and the penalty section. The offense conduct has no problem with it being cocaine or a mixture of cocaine. So in this case, I'll just read you. If the drug involved in the violation is cocaine, so you got cocaine, we know there's some cocaine, or a compound mixture, preparation, or substance containing cocaine, so the entire thing, then the person's guilty of possession of cocaine. I have no problem with that. Possession of cocaine is okay. Mr. Hamilton, if the jury believed the lab tech that that was some cocaine, he's guilty of possession of cocaine. What should his penalty be? The legislature says, if the amount of the drug involved, and drug would be defined as everything that they've got, the mixture, if you will, even though the lab tech in this case that they called said there was no mixture.
Was the lab tech asked if it was a compound or a preparation, or there were 4 different things that were stated, so she said no to a mixture, did she say yes to any of the other
She didn't say yes to any other ones,
Was
and
she asked the
she was
question?
never asked the rest. I think that at the trial court, the accusation or the theory that the state had was that it was a mixture. The state never asked, did you see a compound, preparation, anything like that? So no, this cocaine's inclusion in the compound, or substance or preparation is something that the state is now just assuming. There was no evidence of that. It says, equals or exceeds 5 grams but is less than 10 grams of cocaine. You go to the next, subsection C. Equals or exceeds 10 grams but is less than 20 grams of cocaine. If the words of cocaine are not there, then their argument makes total sense because you've got a drug which includes everything, but they say of cocaine. Why? There's no explanation from the state on that. Just that, well, some old cases that rely on prior law and prior definitions say that you weigh the entire thing. Come on, Judge, it's bulk amount. Bulk amount, if you read the statute right now, does not exist. The definition of cocaine used to include the entire thing. It doesn't anymore, but the state keeps citing cases that rely on the old law and say, it's clear. 9th District, you've said many times that you don't have to weigh the entire thing. But forgot to mention, by the way, that definition's completely changed. It was a different statute. So it'd be like me saying, hey, 20 years ago, my client, you said, was allowed to get this domestic violence sealed. Well, what would the response be? Well, the statute's changed. That's what the response should be to the state right now, but it's not. It's, they haven't recognized that. Because there's cases from 1983, 1997, 2004. If you look at all the cases, and I went through in my brief, both to the trial court and to this court, saying, look, this is exactly the language they're relying on in this old case. This 1997 case, that 2004 case, doesn't exist anymore.
Counsel, thank you.
Thank you.
The court will take the matter under advisement and issue a written